Thank you, Mr. Speaker.
Colleagues, I rise to support Bill S-251, Senator Scotcher's bill proposing to repeal Section 43 of the Criminal Code, provisions that authorizes school teachers and parents and persons standing in place of parents to use reasonable force by way of correction. The bill before us continues long and determined efforts to achieve this reform. Over the past 30 years, there has been 17 previous bills in both houses aiming to repeal or amend Section 43, including one by our former colleague, Senator Hervieux-Payette. Why should this attempt, this one, succeed where so many failed before? I suggest 5 reasons. First, repealing Section 43 is no longer just a question of children's rights. As the bill before us recognizes, repealing Section 43 is a necessary step in meeting Canada's commitment to reconciliation as recommended by Call to Action 6 of the Truth and Reconciliation Commission. Second, by doing so, we will join an ever-increasing number of states. In 2004, when the Supreme Court of Canada released its landmark decisions on Section 43 in Canadian Foundation, at the time there were 15 states prohibiting all forms of corporal punishment of children. Today, that number exceeds 65. And an additional 27 states have publicly committed to enacting legislations to explicitly prohibit all forms of corporal punishment of children, however light, in all settings, including the home. Third, repealing Section 43 is a necessary step to place Canada in compliance with its international obligations. It is true, as the Supreme Court majority observed in 2004 in the Canadian Foundation case, that the United Nations Conventions on the Rights of the Child does not explicitly require states parties to ban all corporal punishment of children. However, it is also true that 2 years later, the United Nations Committee on the Rights of Children clarified that the Convention requires states to remove all provisions that allow some degree of violence against children, whether in their homes, their families, or in any other setting. Indeed, the committee specifically referred to the example of permissions for reasonable correction as a type of things that should be removed, which is precisely what Section 43 of our Criminal Code does. As the Committee of the United Nations Committee explained, the Convention, like all human rights instruments, must be regarded as a living instrument, whose interpretation develops over time. Fourth, and perhaps most importantly, the evidence around corporal punishment's efficacy, or rather inefficacy, is clear and compelling. The corporal punishment of children and youth plays no useful role in their upbringing and poses only risk to their development, as was said by previous speakers on this very bill. Indeed, the wealth of research around the adverse lifespan consequences for children and the societal harm associated with physical punishment should give us a pause. This brings me to my fifth and final reason on why this attempt to repeal Section 43 must succeed. It is the fact that public acceptance of Section 43 is heading in only one direction, downwards. Since 2004, 673 organizations from coast to coast have signed the Joint Statement on Physical Punishment of Children and Youth. This statement developed by a national coalition of organizations facilitated by the Children's Hospitals of Eastern Ontario, recommends various actions, including, I quote, the provision of the same protection of children from physical assault as is given to Canadian adults. This means repealing Section 43, which denies children, and only children, equal protection of the Criminal Code law's assault provisions. At this juncture, it is perhaps helpful to spend a moment reflecting on the history of Section 43 to understand that its sources are no longer relevant and by far obsolete. Section 43's immediate antecedents lie in Parliament of Canada original codifications of the Criminal Code in 1882, slightly after Confederation. At the time, Section 55 was the codification of the common law rule that recognized the concept of reasonable correction as being part of the English common law. However, reasonable correction is far from a Canadian invention. As I said, it was a common law principle. And this principle was established in a case rendered in 1860 called Hopley. That decision dealt with a manslaughter charge against a teacher who, in the course of administering corporal punishment, beat a teenage pupil to death. Although the teacher was convicted, Hopley, in the case of Hopley, endorsed the permissibility of inflicting moderate and reasonable corporal punishment for the purpose of, and I quote, correcting what is evil in the child, end of quote. It is interesting to know that Hopley reasoning rests on Roman principle, including the principle of patria potestas, whereunder fathers held the power of life and death over their children. William Blackstone's commentaries on the laws of England wrote, and I quote, the ancient Roman laws gave the father a power of life and death over his children, upon this principle that he who gave had also the power of taking away. The power of a parent by our English laws is much more moderate, but still sufficient to keep the child in order and obedience. He may lawfully correct his child, being underage, in a reasonable manner, for this is for the benefit of his education. He may also delegate part of his parental authority during his life to the tutor or schoolmaster of his child, who is then in loco parentis and has such a portion of the power of the parent committed to his charge, i.e., that of restraint and correction. End of quote. Of course, the range of conduct defensible under Section 43 since the 2004 judgment of the Supreme Court is much more curtailed than what was once allowed in the name of reasonable correction. However, the source of that principle goes back to the Roman Empire and 2,000 years ago, when we can say a man was the owner of his house, of his wife, of his children, and has ultimate power to correct because education was done through correction. But fortunately, school teachers are no longer of that class of people, as my fiercest leader knows. However, as we consider Section 43's future, it is important, I believe, to not lose inside the past. The raison d'être of this Section 43 is, and always has been, about one thing, and only one thing: allowing the corporal punishment of children to correct them. I would like to conclude by addressing the apprehension around the consequences that might flow from the repeal of Section 43. Namely, as Justice Arbour framed it in 2004, and she was dissenting, the concern that striking down Section 43 will expose parents or persons standing in the place of parents to the blunt instrument of the criminal law for every minor instances of technical assault. Of course, she was making fun of the threat. To borrow one example from debate, I think we can all agree, colleagues, that no parent should face criminal sanctions for forcing a reluctant child into a car seat. However, I will also hope we can all agree that no parent should enjoy permissions to give their child a whack after getting them into the car seat. Likewise, I think we can all agree that no teacher should face criminal sanction for intervening to stop a fight or requiring a disruptive student to leave the classroom. It did happen to me in the past. I was asked to go in the corridor a few times. I'm much better now. However, I will also hope we can all agree that no teacher should enjoy permission to whip out the ruler, or worse, as was commonplace not long ago. I do remember the nun using the ruler in the classroom and asking you to come forward, put your hand first, and then slap it. Interacting with children, whether as parents or teachers, engage a range of physical contact that falls far short of the conduct that comes to mind when we think of corporal punishment. That is undeniable. The question then becomes whether the criminal law and criminal process, as currently structured, could be used to charge these people that are just preventing something to happen. A precise answer to this question is perhaps best left to the committee in its study. However, I would like to point out that the words of the Supreme Court, as well as the experience of other countries that have get rid of provisions similar to Section 43, have not shown that kind of odd consequence. In 2004, when the Supreme Court majority upheld Section 43's constitutionality, 3 of the 9 judges disagree. Justice Harbour, in particular, took great efforts to address the questions of how parents and teachers will be protected despite the removal of Section 43, considering the state of the law in Canada. She concluded, and I quote, that the common law defenses of necessity and de minimis adequately protect parents and teachers from excusable or trivial conduct. We will also be remiss to ignore the important and effective role of prosecutorial discretion in weeding out trivial and insignificant cases. Likewise, Section 34 of the Criminal Code contemplates the defense of oneself or others. You intervene to protect yourself or to protect somebody. That's the defense. In the case of a teacher who intervenes between fighting students, for instance, it is difficult to imagine what protection, if any, Section 43 adds to the protection already available under Section 34 of the Criminal Code. In the international context, a recent experience in New Zealand, where they got rid of similar provisions, have shown that teachers have not been sued by the Crown for having separated children that were fighting. In fact, in 2017, New Zealand went further. It amended the Crimes Act to explicitly prohibit all corporal punishment of children, including in their home. That was targeted to parents. Similarly, in 2000, the Israeli Supreme Court did away with the defense of reasonable correction, which until then found expressions in the country's common law source. And they said, as for insignificant cases that do not justify enforcement within the framework of the criminal law, the court raised the mechanism of prosecutorial discretion, the principle of de minimis, and the principle of necessity. In conclusion, I think our Legal and Constitutional Affairs Committee could look carefully to that bill and dispel the concerns that were raised by some association of teachers, and try to put everything in context and remind the principle that Section 43 can go away and nothing of a disaster will occur afterwards. Colleagues, I think it's time to send to Canadians the message that the power to impose physical correction is not the right way to educate children. That's not the way we educate our children nowadays. Maybe that was the one the Romans thought it was the way to go, but I think we should depart from these old sources. Thank you very much. Merci.